Hello, it's Anna Loutfi from the Bad Law Project. Many of you will be aware that we had a launch on behalf of the Bad Law Project and Reclaim Education on the 13th of July, a few days ago, where we announced our intention to sue the Department for Education for omitting to act on foreseeable harms to children as a result of the promotion of gender transitioning in schools, and for failing to stop political indoctrination of children, which we say is unlawful under the Education Act 1996. I will start by saying that I have been absolutely blown away by the support from citizens, parents, teachers, young people, all manner of individuals and representatives of different communities in this country to that launch. I feel completely humbled, actually, by the amount of outreach that I have experienced in the last few days, with people asking for help, people wanting to offer support and offer information. It has been staggering, and I would like to thank every one of you for that support. It is greatly appreciated, but more than that, it's actually very telling. What it tells me, as somebody with basic qualifications in the social sciences, leaving aside my legal qualifications, is that there is a building movement in this country by large swathes of the British public to have the government address whether or not the content of PSHE in many schools, as taught, is lawful. And it is my position, it is the position of the Bad Law Project, that what the public are telling us is that the consensus is that it isn't lawful. And the reading that the public are making is on the basis of their understanding of the law. And the Bad Law Project's position is that the law is clear on this point, that PSHE as taught is unlawful, and that the large majority from whom we have been hearing of late is right on the law. And that is as it should be in a democratic society, because in a democratic society that is governed constitutionally by the basic principle of the rule of law, that principle is that the law should be clear and accessible to all, and nobody is above the law, and that the government must uphold the law, and primarily the law should not be administered in an arbitrary way. What we've seen over the last few years, as attention has been paid to the growing prominence of the charity sector in schools, is that the third sector, or the charity sector, is a law unto itself, and it is not accountable to anyone. And no matter what it does, or what it teaches, or what content it provides, for some reason the public are not allowed to raise questions or red flags about the potentially unlawful content of that material. And this movement that I spoke of earlier, which is growing, it's a grassroots movement of concerned citizens and parents and teachers and young people and educational specialists and lawyers. This movement is telling the government in no uncertain terms that their concerns aren't going away, they are getting worse, and that we will not stop until we have clarity on this issue. Why is this so important at this particular juncture? Well, I've mentioned our launch on the 13th of July. That launch of the Bad Law Project and Reclaim Education came at the same time as a huge kerfuffle arose in government circles around the so-called transgender guidance in schools that the government was due to issue. It is clear to me that there are elements within our government who do want to tackle the issue of gender transitioning in schools and practices which are clearly encouraging children to socially and medically transition by identifying out of their natal sex, their birth sex. But just after the launch took place of Reclaim Education and the Bad Law Project, and we announced our intentions to sue the Department for Education, the Attorney General, Victoria Prentice, and her government legal department warned the Prime Minister, Rishi Sunak, that on their interpretation of equality law, the protected characteristic of gender reassignment that appears as a protected characteristic under the Equality Act should be interpreted to mean that any attempt to ban or clamp down on the transitioning of children in our schools, by our schools, could potentially be discriminatory under the 2010 Act. And I spoke about this very briefly on Talk TV's Vanessa Felt's show a few days ago. The Telegraph ran with this story and flagged it as the government wanting to ban social transitioning or ban children from changing their gender in schools. But Kemi Badenoch, the Minister for Equalities, quickly intervened and stated that actually that wasn't quite the government's position, and subsequently the Telegraph removed their article. So there is a lot of questions circling at the moment, a lot of confusion around what the government's position is, and quite understandably a lot of confusion about what on earth transitioning children means as a matter of practice, educational practice and policy, and as a matter of law. So I thought I would take this opportunity to come back to our growing audience to clarify the Bad Law Project's position on this issue. And it's twofold. Our first position is that the overwhelming reaction from members of the public to the Bad Law Project's intention to sue the Department for Education, as I say, a reaction that has come from every sector of society, regardless of religious faith or none, or ethnic denomination, or class background, or training, or professional qualifications. We are seeing a huge swathe of the British public that says to us that there is a consensus on what the current law says. That is our first position, that there is some consensus amongst the British public on what the law says. And the second position of the Bad Law Project is that we agree with that swathe of public opinion that the law is clear, and our position is that the public is right to be clear on the law because the law is clear. The Gender Recognition Act, Section 1, subsection 1, spells out in black and white that a person may make an application for a gender recognition certificate on the basis of having been diagnosed with a condition called gender dysphoria, having opted to live for at least 2 years in the so-called opposite gender, until death, that is Section 2, subsection 1c of the Gender Recognition Act. But that is a procedure available to persons aged at least 18. If you go to the Equality Act 2010, Section 7, subsection 1, you will find gender reassignment listed as a protected characteristic and defined in the Equality Act as a process of reassigning sex. For example, by changing the physiological attributes of sex. There is surely no controversy here. The Bad Law Project's position is uncontroversial on our interpretation of the Gender Recognition Act and our interpretation of the Equality Act 2010, which is in line with the interpretation of large numbers of the British public. The Gender Recognition Act does not and cannot apply to persons under the age of 18, and therefore gender reassignment as a protected characteristic is not automatically applicable to persons under the age of 18. That is a common sense reading of existing statute. Now, we also have under the Equality Act 2010 the protected characteristic of age. If you go to Section 5 of the Equality Act, you'll find that age is listed as a protected characteristic, which means basically you cannot discriminate against somebody on the basis of their age. However, for obvious reasons, for obvious moral and logical and common sense reasons, age discrimination provisions relating, for example, to the provision of goods and services do not extend to children or children in schools, because children have to be treated in an age-appropriate manner relative to their capacity, their maturity, the level of responsibilities that they hold, and their stage of development. Similarly, and this is something so uncontroversial that nobody in this country seems to be debating it, talking about it, or worried about it, we don't, as a society, encourage children in age-inappropriate practices in school or outside of school if they are under a certain age, because it would be age inappropriate. The encouraging, for example, of the undertaking of body modification practices such as tattooing or cosmetic surgery. We don't encourage children to have sexual relationships with persons when they are under the age of lawful consent, or we shouldn't be. And so the endorsing or encouraging of children in a blanket fashion as a matter of equality, diversity and inclusion policies in schools to engage in practices that are age inappropriate when they are under the age of majority is clearly engaging a question of lawfulness. And if that wasn't the case, then perhaps the Attorney General should advocate for the abolition of all age restrictions on all products, and perhaps within the criminal jurisdiction advocate for a reading of the law that says all ages of sexual consent should be abolished in law. Now, the Attorney General, at a recent talk that she gave on the 10th of July to the Institute for Government, upheld the principles of the rule of law, which she rightly states are fundamental to a democratic society. In particular, and I've mentioned these legal foundational principles already, the principle that the government has to comply with the law and that the law cannot be inaccessible or unclear or administered in an arbitrary fashion. And these principles are commonplaces of legal jurisprudence. So when the law is clear, as we say it is, and when we see unruly or rogue elements within our society who are not accountable to the demos, to the citizenry, acting in breach of clear law, when there is a public outcry that the third sector is acting in breach of the clear law because the content of personal social health and education, personal social health and economic education is clearly questionable, we do not accept the Attorney General's position that PSHE must be lawful purely on the grounds that it is mandated by statute to be taught, because what the Attorney General has not done is address the content of PSHE materials. We need a public consultation on the content of PSHE materials and whether that content and the practices that accompany that content, that distribution, often conducted in conditions of high secrecy, is or is not lawful. We note also the silence that there has been since our launch on the question of whether sex education is potentially in breach of the criminal law on non-contact child sex abuse. And we continue to make our position clear that gender reassignment as a procedure is available to persons of 18 and over for a very good reason. And so we continue to gather our legal and factual evidence in order that we may hold the Department for Education to account. And we seek a moratorium in this country on the content of PSHE. We want that content scrutinised, and we want recognition that that content causes harm to children and to families recognised. A movement is growing in this country, a grassroots movement to reclaim education and law from political activists who have decided that they decide the law, not elected politicians, not judicial experts who interpret the law in our courts, but they, political activists with political agendas, accountable to no one. And the movement to expose that political activism that is basically stealing the law from the British public is not going to go away, it is growing. So watch this space. Continue to support us. Visit our crowdfunder at democracy3.org, and please be patient as we try to get back to every single one of you, individual, community and family, that has reached out to us in dire straits, in distress, as a result of this horrendous appropriation of our educational sector. We say to you, we're listening, we will be in touch, and we would like, again, to thank you unconditionally for your ongoing support. Thank you very much.